More now on a story that's getting a lot of reaction online. A DC homeowner claims a woman has taken over her rental home and refuses to leave. And up until now, she's run into one legal brick wall after another. So joining us now is Aaron Sokolow, a DC-based lawyer who specializes in landlord and tenant cases. Aaron, thank you so much for being with us.
Thanks for having me.
Talk to us about this, because this has just been a wild story, and it's raised probably the biggest question is, how is squatting even allowed to happen?
So in theory, squatting is not legal and the homeowner should have some remedy. The problem is in the logistical way that a homeowner can get a remedy. And what you're describing in this case that you've been reviewing is that there's a dispute. The individual who's there says she's a tenant, the homeowner says that she's not, and you go down to court on an emergency hearing and there's a judge sitting there and the judge is going to hear from both. But the district is so pro-tenant and so fearful that there will be a wrongful eviction or a self-help eviction where the owner changes locks or turns off utilities or does something to cause occupant to leave without court order, that the judge is going to err on the side of caution. And if the occupant can show something that leads the court to say that there's a possibility that she's allowed to stay there, the court could grant the occupant's request at an injunction and mandate that the owner keeps her there until she gets awarded a proper eviction. And the problem is, in the district, that can take months and months, and it puts homeowners in a really tough spot in the situation you've described.
Oh my goodness. I mean, you're shining so much light on the court process, what that actually looks like. That being said, would you say the laws in DC are favorable to squatters?
Well, they're favorable to tenants, and one person's squatter is another person's alleged squatter, an actual tenant, and the court is going to make sure that it finds out the answer to that preliminary question of, has that individual achieved tenancy status or not? And so you're starting with the conclusion that the person's a tenant, but that individual has a right to go to court and try to prove that she's actually a tenant and afforded all of the rights of tenants in the district. And therein lies the rub. It's not easy to get a court to find an answer to that question. It seems simple. In the eyes of the law, it could become very complicated, especially in the district.
How common is this? You say especially in the district. How common is this problem?
I have personally been involved in a handful of these over the years. So it's not every day that you see it. It's certainly a worst case scenario, but I've seen it before. So it's not a unicorn. It's something that comes up. Remember, in the district, you don't need to have a written lease. You know, a tenant can be defined very broadly. So if an individual can come, and in this case, it's a utility bill is in their name, and that's a common factor that a court would look at. If the tenant, if the occupant can say, you know, here's my proof of some payment, that can be enough. You know, I've had cases where my client, a property owner, a landlord, says this person literally broke in, but by the time, you know, it gets to the courthouse, they have some mail with their name and the property address on it or something like that. And the court proceeds out of an abundance of caution and is so hesitant to sign off on a self-help eviction that they say, well, you know, because the prejudice to locking this person out would be so high, we're going to give them the benefit of the doubt until we can get to the bottom of that. And get to the bottom of that can be a trial that's held 9 months later.
Just the timeline, which, as we kind of were seeing in the package, the payments, this can be excruciating for people trying to pay and not even living at a property in the meantime. Aaron, what can homeowners actually do then in a situation like this?
My biggest recommendation is to be present and to understand what's going on. Accidental landlords, you know, if you just say, oh, I'm not an institutional landlord, I'm just renting out my room. They are held to the same rigors and standards as every other landlord in the city. So being knowledgeable about the law, being knowledgeable about what a court might say about these certain situations is of the utmost importance, as is being hands-on at the property. Usually when I've seen this, there's some length of time where they say, oh, you know, we didn't check on that unit for a while and we don't know what's been going on there. If you catch this right away, you might have a better chance at fending off an allegation that your squatter can allege a tenancy.
Why do you think, from your experience and what you've seen, that more hasn't been done to protect landlords and homeowners?
There's a very well coordinated and well educated and talented group of pro-tenant lobby in the district that really tries to make the laws as favorable for tenants as possible, and they've succeeded to a large part. So this would be a question for everyone's council member to say, why are the laws as they are? But the courts that enforce the laws are very hesitant to take an action that's going to kick someone out of a place if they actually have an entitlement to be there.
Lawyer Aaron Sokolow, thank you so much for joining us to talk about what truly is a very wild story. Thank you so much for being with us.
You're welcome. Have a good day.
You too. And stay with us because we're going to be right back after this quick break.